and economic rights advocates. I focus on tenant rights, and today I'm going to give a brief presentation on notices to vacate and the Tenant Protection Act in California. Please keep in mind that these laws change with some regularity, so just make sure that when you watch this, you check to see if there are any updates. And also, none of what I'm saying constitutes legal advice. If you have any questions, you're welcome to call our office directly or email us, and I have the contact information at the end of this slideshow. Okay, so basic tenant rights, notices to vacate. There are different types of reasons why a tenant might be required to vacate, or why a landlord might serve a tenant with a notice to vacate. And depending on the reason, the landlord must give a certain amount of notice, and the landlord must give prior written notice to evict for any reason. So the notice period can be, for example, 3 days, 5 days, 60 days, 120 days, a year. It really kind of depends on the situation and what type of housing that person has. So for example, some types of public housing, tenants are required to have more notice. And then also right now, in November 2022, Alameda County and the city of Oakland still have a temporary eviction ban during COVID. So under those laws, in Alameda County, people can only be evicted for a very limited number of reasons. But in Alameda County, the moratorium will expire 60 days after the end of the local emergency. We're still in a local emergency, and we don't know yet when it will end. But it could be soon, as soon as early next year, or potentially sooner than that. And you can find more information at these links. So the city of Oakland has its own eviction moratorium, and then also Alameda County has its own, which applies to the whole county. And then so for notices to vacate, in most cases, there's what's called a cure period. So the tenant will have a period of time, for example, after not paying rent or being late on rent, or a type of lease violation to cure that. So if most people have probably heard of a 3-day notice to pay rent or quit. So that means that the tenant has 3 days to pay the rent or vacate the property. But of course, there's a lot more involved in that whole process. So don't, it's definitely, you want to look at this kind of with a bigger picture perspective, and make sure to talk to an attorney if you are served with any type of notice. However, if the violation is egregious, so for example, there's a severe nuisance, or the tenant has caused substantial damage to the property and criminal activity on the premises, a cure period is not required, and the tenant may be required to vacate the unit within a certain time frame. That's typically 3 days, without having the opportunity to fix the issue. So notice of termination of leases. So they're generally, what we see most often is either a month-to-month lease or a fixed term lease. So that's a year typically, though it could be a different amount of time. So in a month-to-month lease, if the tenant has been living in the unit for at least 30 days, the landlord must provide the tenant with the 30 days written notice. And if the tenant has been living in the unit for more than 1 year, the landlord must give the tenant 60 days written notice. And then also, if the tenant wants to move out, the tenant must give the landlord 30 days written notice. And then in a year-long lease, in most cases, the landlord cannot terminate a lease without cause before the end of the term. So I'll get into this later, but cause means the landlord has to have a certain accepted legal reason to evict a tenant. So the lease will change to a month-to-month tenancy at the end of the lease term. So for example, if it's a year-long lease, the lease will change to a month-to-month tenancy after the end of the year, unless the landlord and tenant agree to renew for another year. And the end of a lease does not constitute a just cause, meaning just the end of the lease is not a valid enough reason for a landlord to evict in most cases. So just, I'll get into this later also, but unfortunately not all properties, tenant properties are protected by just cause, but many, probably a majority of them in California are. And I'll get into that more later. But when the lease ends and the tenant refuses to sign a lease with the same terms, substantially the same terms, that could put the tenant at risk for eviction for refusing to sign a new lease. So now I'll talk a little bit more about the Tenant Protection Act and good cause. So this is a statewide law in California. You can find it under Civil Code 1946.2. So there are two types of just cause, as I mentioned before. Just cause essentially means that it's a specified list of reasons why a landlord can evict a tenant. And if this law applies to a tenant's property and the landlord tries to evict that tenant without a reason listed in the law, that would mean that the landlord is trying to evict the tenant without just cause. So that's illegal. So the two types of just cause are no fault just cause and at fault just cause. So under no fault just cause, it's what it sounds like the tenant has not violated the lease in any way. So for example, the owner or the owner's family member moves in. If this is in the lease or the tenant agrees to it in writing, that's accepted. Intent to demolish or substantially remodel the property, the landlord withdraws the unit from the rental market. This is commonly known as the Ellis Act, and I'll talk a little bit more about that later. And then also in order to comply with a court order related to habitability, in certain circumstances where the tenant is not responsible for the habitability problems or other types of no fault cases, the landlord may be required to pay for limited relocation assistance to the tenants. Usually the local laws will kind of describe that process and the minimum relocation amount that a landlord would be required to give to the tenant. So at fault just cause means that the tenant has violated a material term of the lease or engaged in other specified actions. So for example, obvious ones, non-payment of rent, criminal activity on the premises, refusal to allow the landlord to enter lawfully. And as I mentioned earlier, please keep in mind that the Tenant Protection Act just cause protections don't apply to all tenants. And as I talked about before, the Alameda County eviction moratorium is in place for 60 days after until 60 days after the end of the local emergency. So here are the exceptions to just cause. So statewide just cause does not apply to transient and tourist hotels, housing in a nonprofit hospital, religious facility, extended care facility, student dorms, a duplex where the landlord lives on the property, rentals that were built in the last 15 years, so apartment buildings, single family homes not owned by a corporation. This category can get a little bit tricky, but generally if the single family home is owned by, an individual or a couple, most of the time it's not protected by just cause, unfortunately. But if you live in a single family home and you receive a notice, you would definitely want to check with an attorney to see whether or not the statewide just cause applies to your property. And then it also doesn't apply to properties where the tenant shares a bathroom and kitchen with the landlord. So I'm going to talk a little bit more specifically about notices to vacate the Ellis Act. So again, the Ellis Act is a type of eviction when the landlord wants to take the property off of the rental market, and the law can be found at California Government Code section 7060 to 7060.7. So for Ellis Act evictions, at a minimum, the landlord must give 60 days notice to the tenant to vacate, but cities and different localities that already have their own rent control laws in place can impose longer notice periods or more restrictions to the whole Ellis Act process. So for example, some cities might impose a 120-day notice period for Ellis Act evictions and a 1-year notice period for tenants who have a disability or are seniors. So Oakland has some pretty strong Ellis Act protections, but you definitely want to look to the local laws and speak with an attorney if you're served with an Ellis Act notice. There are many specific requirements that a landlord must follow, and it's oftentimes not difficult for them to make a mistake. And so if there's any problem with the notice, it is potentially a possibility that a tenant could have more time to find a new place to live and to stay in the building, or potentially not move out at all if the notice is improper and defective. So definitely make sure a lawyer reviews the notice. So now I'm going to talk a little bit about statewide rent control. This is also in the Tenant Protection Act under Civil Code section 1947.12. Again, this doesn't apply to all tenant properties in the state. And the same exceptions that I listed before apply to statewide rent control, but also local cities also often have their own rent control laws that you would want to check as well. So under the statewide rent control law, rent cannot be raised by more than 5% plus the local consumer price index, or 10%, whichever is lower. So the local consumer price index is essentially the kind of the regional rate of inflation, or like Oakland and other cities will have their own CPI posted on their website. Usually you can find it pretty easily. So for example, here is Oakland. I think the last time I checked, the CPI for Oakland was 3%. It might be different now. So under this law, under state law in Oakland, a tenant's rent cannot be raised by more than 5%, and let's just say the Oakland CPI is 3%. So the rent cannot be raised by more than 8%. So 5 plus 3% is 8, and that's obviously lower than 10. And then you can also check this website, the Bureau of Labor and Statistics, to determine what the local consumer price index is. And also, of course, again, I recommend consulting with an attorney to kind of figure out whether or not a rent increase is legal. And under this law, rent can only be increased twice in any given 12-month period. And the landlord must provide proper rent increase notice to tenants. And again, there are exceptions to the statewide rent control law Again, they're the same exceptions as the just cause law, but I'll just go over it briefly. Tourist hotels, nonprofit hospitals, religious facilities, student dorms, duplex where the landlord lives on the property, housing restricted by a deed, regulatory restrictions, or a limit on affordability. So to lower moderate income households, so this is like not Section 8, it's like low-income housing tax credit, other types of public subsidy programs. So you definitely want to check again with an attorney to see whether or not the type of subsidy you receive would be exempted from this law. The Tenant Protection Act does apply to people with Section 8 vouchers, so that's important to keep in mind. Again, single family homes where the home is not owned by a corporation, like a company. Again, you would want to check that, to see if that exception applies if you live in a single family home. And then buildings where the certificate of occupancy is less than 15 years old. Okay, so that's everything, just a brief overview of the Tenant Protection Act and notices to vacate. If you have any more questions, you're welcome to call our number down here. It's 510-271-8443, or go to our website. And there's a page where you can submit a question over email. And yeah, we're happy to answer any related questions you have, and potentially you might be able to be set up to talk with an attorney to discuss this specific problem you're dealing with. Okay, thank you, everyone.